turn our attention to the next order of business, and on that we have hearing for Senate Bill 83, and we will now open the hearing for Senate Bill 83, and our first proponent will be Melissa Johnson. She is the Senior Assistant Attorney General and Chair for the State Child Death Review Board. Welcome, Melissa.
Thank you. I appreciate the opportunity to be here today and testify on behalf of Senate Bill 83. We believe that this is important legislation that would clarify the existing statute. It would do three primary things for the Child Death Review Board if it were passed. First, it would allow us to participate in a national database and a case reporting system that would allow us to better be able to analyze our data. We had a legacy database in the past, but that's no longer available to us. So we are just trying to manage the data internally at this time, and the participation in the case reporting system would be of great benefit to us. It is something that's free, and I know you'll hear from Ms. Collier later on that many other states participate in, and we would only use de-identified data in that database, in that you couldn't go in and search for a child by name or anything like that. You would just be able to, Kansas would be able to analyze their data better, and if someone else was doing research on the system, they would only be able to search maybe for drowning deaths and see that Kansas had drowning deaths of a particular age group, but no name, anything like that would be available to anybody else. Second, it would allow the professionals that are on the board to remove the conflict that they currently have with the confidentiality requirements of the board, but also with their professional licensing obligations. For example, if you're a doctor on the board right now and you believe that you see something that would rise to the level that you needed to make a complaint with the Board of Healing Arts, right now they're prevented from doing that, because their professional licensing obligation tells them that they must make the report, but the confidentiality statutes for the Child Death Review Board says that they can't make the report. So we're just trying to resolve that conflict for the members of our board and make sure that if they find information that they believe needs to be in a report to the professional licensing organization, that they're able to do that and fulfill the policy reasons behind that obligation. The third thing that this clarification of the existing statute would do would be allow the board to release information if it was in cases of abuse and neglect to law enforcement and to the prosecutors if they didn't previously have that information. During the course of reviewing every child death in Kansas, the board has come across numerous instances where all information wasn't originally available at the local level when they were first investigating the death or trying to make a decision on whether or not someone should be held accountable and someone should be prosecuted. By hindsight or access to additional information or whatever means it might be, the board has come across several cases in the last few years where we have classified the deaths as homicides. They weren't originally classified that way locally. They might be an accident or they might be undetermined. And we believe we have information that's important to give to law enforcement and to the local prosecutors to help them make the best decision they can. Currently, we have some conflicts there where we have the information, but we're prevented from giving them that information to them because of the confidentiality requirements. So the clarification to this bill would resolve that issue and allow us to give the information to the people that need it to make good decisions in the cases going forward. So we would support the passage of this bill, and I'd be happy to answer any questions that you might have.
Melissa, thank you very much for your testimony. And committee members and revisor's office, I apologize. I skipped over their time to shine and give us the bill explanation. So we will back up and have a bill explanation. So Jenna, thank you.
Thank you, Mr. Chair. I fear that Melissa did such a good job that there's not a ton that I'm going to say that won't be redundant, and so I will just do a brief, as it were. Senate Bill 83 creates exceptions to the confidentiality requirement of state child death review board documents. It amends KSA 2020 sub 22A 243, which is the statute establishing the state child death review board. The current law only gives one. Current law requires that the information and reports of this board be kept confidential, and the only exception currently in law is for allowing disclosure to members of the legislature who are responsible for enabling or appropriating legislation. And this bill would strike that exception and replace it with 7 others. And the first is, again, the member of the legislature or legislative committee with enabling or appropriating legislation, but it would require it to be disclosed in a closed or executive meeting where steps to maintain the privacy have been taken. It also would allow a person or entity contracting with the board if the disclosure is essential for the contract. The third exception would be any person or entity if the disclosed material is statistical or conclusions of the board similar to those contained in its annual report, or the fourth and fifth are a law enforcement agency or a county or district attorney related to prosecuting a child's death, which was already spoken about. And the sixth is related to those disciplinary complaints, would allow disclosure to the licensing body. And the seventh is a governmental agency or organization with a federal-wide assurance. And this would be for health or education research, and the personally identifiable information would have to be redacted. And I'll be happy to answer any questions if there are any.
Committee, do we have any questions for the reviser about the bill? Senator Petty.
Thank you, Mr. Chairman. Jenna, on the list of items that you just mentioned for disclosure, the first one, when it came to any member of the legislature or legislative committee, so could an individual legislator ask for information, or would they have to be doing it as part of a specific appropriation committee?
It would have to be as part of their official functions. So you see that language in, it'll be page 2, line 40. It'd be carrying out official functions of such member or committee. And I mean, you can sort of interpret that how as, I don't know, as broad or as narrow as you would want to, but I think it would have to be tied to having legislative or appropriating legislation. So I think they'd either have to be sitting on a committee or a member of the committee that, or a member of a committee dealing with either appropriations or the enabling or sort of the oversight of the State Child Death Review Board. And it would require it to be in that closed or executive session. So I think as an individual legislator just asking for it, sort of on a whim, I don't think there'd be a great case for disclosing it under those circumstances.
Just as a follow-up, Mr. Chairman, but those words that say is carrying out the official function of such member, does pretty broaden it, doesn't it?
And again, it would have to be tied to the work of the committee, and it would have to be in that the committee recesses into a closed or executive meeting.
Thank you.
So you kind of have to read all of it at once.
Senator Thompson.
Thank you, Mr. Chair. Jenna, quick question on page 3 at the top, line 1 through 4. It says if the board has determined that the disclosure of information and records is essential for the completion of the contract, what's that referring to? It's early in the morning and my mind's a little foggy.
I actually think Melissa might be a better person to answer that question. I think what it would refer to would be being part of that database that she talked about. And I can let her jump in if she can.
Sure. The intent behind that was just to allow us to contract with the National Center and allow us to be part of the case reporting system for having a contract with them.
Okay, so in other words, just providing the statistical data so that they can complete their report. correct? Okay,
Correct.
thank you, Mr.
Great.
Chair.
Are there any more questions for Jenna? Seeing none. Melissa, we're going to hold questions in committee. We're going to hold questions till the end of all the proponents. Next up, as a proponent, Ed Klump, Legislative Liaison for KACOP, KSA, and KPOA. Welcome, Ed.
Thank you, Mr. Chairman. Thanks to the committee for allowing us to provide this testimony real quickly. My name is Ed Klump. Some of you may not be familiar with me. I've been doing lobbying for these three associations for quite a few years now. Since I retired from the Topeka Police Department, I had 35 years of experience with law enforcement as an officer. And when I retired, I'd been chief of police in Topeka for 5 years. So our associations come to you today in support of Senate Bill 83. We think this provision that we're particularly looking at, which you find on page 3, lines 8 through 19, which allow the exchange of information to law enforcement and prosecutors. We believe this provision is extremely important addition, and it's critical for us to have access to that information to assure that we're doing a complete and thorough report. It's a limited disclosure of that information for investigative purposes. I think you'd all agree it's good public policy to protect our children, regardless of the frequency a situation occurs where we may not have such information the board gets. But if there's any reason the board believes that law enforcement does not have information they have, particularly if we're not even aware of a child abuse or neglect case, we believe that's very important for us to have access to that information, be apprised of it. We do have one amendment that we'd like the committee to consider, and that would be in subsection B of those sections I referred to, that's found on lines 13 and 19 on page 3. To add to the end of that, or if the board has knowledge of a law enforcement investigation involving the death of a child. The reason we believe this slight addition expansion is important is, as we read the bill as it's currently worded, they can share that information if they determine that the child's death was from abuse or neglect. There could be situations where they determine it wasn't from abuse or neglect, but because of the reports that they've gathered, they can be aware that a law enforcement investigation of the death is ongoing. And it's very important for us as investigators, not only to identify the suspects in these cases, but also clear suspects who did not commit any crime, and also for us to determine if the acts that we're investigating were indeed not even a crime at all. And by doing this, it would assure that we get access to this information that may be exculpatory in nature, could clear a suspect who we're looking at, or perhaps determine that the death was not criminal at all. And ultimately, the goal of this would be to avoid any wrongful conviction. And I think it's a pretty simple amendment. It doesn't expand this too far, but gets to the essence of what we're trying to accomplish with this bill. Mr. Chairman, we would encourage the committee to move this bill forward favorably, hopefully with our amendment attached. And if any of the committee members would like to work with us on getting an amendment drafted to present when you work the bill, we'd be glad to hear from them. My contact information is at the bottom of our testimony, and I'll stand for questions at the appropriate time.
Ed, thank you for your testimony. Next up, we have Phyllis Larimore, Legislative Liaison for Safe Kids Kansas. Phyllis, welcome to the committee. I apologize. I need to read a little bit better. So committee members, I will draw to your attention at this time, we do just have written only for Phyllis Larimore and Rachel Marsh. Do we have any questions from the committee for any of the proponent testimony? Senator Baumgartner.
Thank you very much, Mr. Chair. My question is for Melissa with regard to, could you please weigh in on the proposed amendment that Mr. Klump provided us? Are you comfortable with that amendment?
My only concern would just be making sure that I understand exactly the language that he's looking for. As I understood, hearing him speak about it, he said any case where there is a law enforcement investigation. In many cases we have, it might be a natural death, but law enforcement's still called. So I think it would be important to clarify the scope of what they're asking for. If it's a natural death that law enforcement's closed their investigation before we ever reviewed it, I don't know that we would necessarily release any information to them unless we found that there was some abuse or neglect involved. So I guess I'm just trying to think through the possible scenario where that could come up. There is a delay in our case reporting. Currently, we are working on 2019 cases. So in most situations, law enforcement has closed their investigation long before we ever review the case. So I guess maybe it would be important to have some discussion about if we have reason to believe there's an ongoing criminal investigation, and clarify and narrow that as much as possible.
Mr. Chair, I would like to recommend, I do believe that the parties that are proponents do need to work together. I feel that when legislators try and splice it together, no one's really very happy with it. But I do know that this is an issue that the State Child Death Review Board has wanted the legislature to address. I think this is the third year. I do think it needs to be taken care of. I do think we need to have this on the books. But I think that the proponents need to work together. I'm more than happy to be a legislator to sign on permission with Jenna that they work on that, but I think we need to get it fixed so that we have what's best for our state and for the review board. Thank you, Mr. Chair.
Thank you, Senator Baumgardner, and I will echo that. Ed, if you could work with Melissa on fine-tuning that language, and then with Senator Baumgardner or Jenna on that, that would be greatly appreciated. Do we have any other questions for any of the conferees? Okay, seeing none. We do have neutral testimony from Abby Coyer. She's the Director of for the National Center for Fatality Review and Prevention. Abby, welcome to the committee.
Thank you, Mr. Chairman, and good morning. Thank you for allowing me to provide this information about the National Fatality Review case reporting system this morning. I'm here to provide factual information about how the system works and not to influence your decision in any way. The National Center that I lead is funded in part by the Health Resources and Services Administration, or HRSA, which is part of the Health and Human Services. At a national level, Child Death Review is a multidisciplinary group of professionals who come together to understand how and why children die. At the National Center, we provide technical assistance to states in a variety of forms. We kind of consider this in two key buckets. The first is programmatic, and the second is related to the National Fatality Review case reporting system, or case reporting system for short. The case reporting system is a free web-based data system used by fatality review teams in 47 states. Currently, the case reporting system is operating on version 5.1 of the software, and it updates every 18 to 24 months. The case reporting system contains a unique set of data that are not available in other data sources. The system was first launched in 2005 after an extensive pilot. The goal of the case reporting system is to collect aggregate de-identified information on the risk and protective factors surrounding the death of a child. The goal of the case reporting system is to inform prevention. The system is organized by cause of death, and significant effort is put into reducing the user's data entry burden. When a user indicates that a child died in a drowning, for example, only questions related to drowning will appear. If users select that the child died in a sleep-related incident as a result of a suicide or the result of child abuse and neglect, there are additional questions in addition to those in the cause of death section. States who use the case reporting system sign a data use agreement. This data use agreement outlines the protections and utilizations of the data. States retain their right to the data. They also retain their ownership. This means each state can define what, if any, uses for de-identified data are allowed at a national center, from the national center, also with approved researchers. Data from the case reporting system have been used in many peer-reviewed journal articles, including many on child maltreatment, infant safe sleep, suicide, and unintentional injury. One example of a study that's been published looked at all child abuse and neglect deaths in the case reporting system. The findings of this study confirmed that as a result of child death review, states expanded their knowledge of child abuse, which improved their ability to do prevention work. The full citation for this study is at the bottom of my testimony. States also control what information they enter into the case reporting system. This allows each state to dedicate the resources that they have to enter the information that is most relevant to them. The case reporting system is housed within our organization, which is a program of the Michigan Public Health Institute. To date, we have never experienced a data breach. As I stated before, there is no charge for using the case reporting system, and extensive technical assistance is available. I want to point out that each state only has access to their own data. Furthermore, within states, there's multiple layers of protection, allowing tailored access depending on an individual's role. The case reporting system contains a unique set of information that has been used throughout the U.S. to drive prevention efforts that have improved the health and safety of communities. Thank you for the opportunity to share this information with you this morning, and I would be happy to answer any questions at the appropriate time.
Thank you, Abby. Committee members, do we have any questions for Abby? Seeing none, Abby, you must have done a really great job. So, committee, with that, there are no other proponents or any opponents to this, and no other neutrals. We will close this hearing on Senate Bill 83. And next, we will turn our attention to Senate Bill 85 and open up the hearing for Senate Bill 85. And for the bill explanation, we have Jenna.
Yes.
Explain the bill.
Excuse me. Thank you, Mr. Chair. All right. Senate Bill 85 requires that the governor and the legislature be given notice when a child in foster care goes missing or spends the night in a case management contractor's facility. This bill, Senate Bill 85, would create a new section of law, and in subsection B, beginning on line 19, would require a foster care management contractor to give notice within 24 hours if a child in foster care goes missing or spends any overnight period in a facility under the control of that contractor. Subsection B2 specifies the information to be included in that report for a missing foster care child, and B3 specifies the information to be included when the child spends the night in that facility. Subsection C would require the Department of Children and Families, after receiving a notice under subsection B, to notify the governor as well as each member of the legislature and the official newspaper of the county where the child went missing. And if a foster care management contractor does not notify the department, so in violation of this section, subsection D would authorize the department to assess a fine of $500 per day to that contractor, and the total amount of those funds would be deposited into the state treasury, or into the state general fund, excuse me. And I'll be happy to take any questions.
Thank you, Jenna. Committee, do we have any questions for Jenna? Seeing none, Jenna? Oh, sorry, I thought you were going to get off the hook, Jenna, but Senator Gossage.
Jenna, can you tell me what the notification is now, or maybe I need to save that for Rachel?
Yes, I believe that there are proponents, or there are people giving testimony who can tell you more about what is detailed in those notices and what's currently required under DCF policy.
Senator Gossage, this is probably more anecdotal than fact, but the way I usually hear it is from a reporter calling me and asking me my opinion on something. So with that, we will now turn to our proponent testimony, and Rachel Marsh, CEO of Children's Alliance of Kansas. Rachel, welcome.
Good morning. You surprised me by having me go first. So just 1 second here while I get ready. Chairman Hildebrand, Vice Chair Gossage, and Ranking Member Petty. My name is Rachel Marsh, and I represent the Children's Alliance of Kansas. The Alliance is an association of 18 private, nonprofit child welfare agencies that work to strengthen children and family well-being in Kansas through advocacy, networking, and education. Among a broad array of services that our members provide, we have child placing agencies that sponsor foster homes, case management providers, residential providers, and PRTF owners and managers, psychiatric residential treatment facilities for those of you who are new to the committee. Our members provide evidence-based services to youth with complex needs at home and in foster care, including youth who come to the attention of DCF due to running behavior, juvenile justice behaviors, substance use needs, and acute mental health needs. Improving services to this population of youth, both before foster care is necessary and in foster care, is one of the Alliance's top priorities for this session. We are very appreciative of this committee for your concern for seeking regular information about youth running behaviors and about youth with such a high level of needs that at times finding stable placement hasn't been possible. We appreciate the opportunity for discussion about how our state can better meet the needs of these youth. Those of you who are new to this committee, I want to start by making sure you are aware that currently case management providers do provide reports to DCF, both on youth who have run away from placement and youth who have no options other than sleeping in a social work office on the rare occasions that happens. In addition, DCF does currently provide the information and data about youth who aren't present in placement on a publicly available website on a daily basis that they update. We know from gathering the data and from our review of these cases over the last few years when this issue emerged, that these youth who are subject of the concern of Senate Bill 85 are youth with a history of significant family trauma. They may be youth with juvenile justice type behavior challenges that have been diverted into foster care. They may be youth with very significant mental health needs or crisis needs who had in the past been unable to immediately access the care that they needed. And we also know that they have substance use and addiction issues. In addition, for some of these youth, effective intervention for the behaviors and care can be complicated by intellectual or developmental disabilities. It's important that we understand the nature of this population so that we know why it can seem like an intractable problem in our state. We would have one clarifying comment about the reporting requirements under section 1B, 1B, one little b, one big B, which currently is drafted regarding that reporting related to a facility under the control of the contractor. What I want to make sure that you understand is that case management providers in this state provide a range of services within the child welfare system. This includes case management, but it also includes managing and sponsoring foster homes, managing residential facilities, PRTFs or the psychiatric facilities, QRTPs, and youth psychiatric hospitals. We would suggest clarifying the language of section 1B, 1B to require reporting only for a child who has spent an overnight period in a facility not licensed as a placement for foster youth under the control of the contractor to avoid any question. Beyond the required reporting contemplated by Senate Bill 85, we look forward to working with this committee to using the data that we do already have about this population. Originally, I believe this bill was filed 2 years ago, and since then we have had a lot of success working with this committee and other committees to help us get attention to meet the needs of youth with running behaviors or the really high needs that mean that Finding appropriate and safe placement has been difficult from time to time. An example of this might be a youth who has been in the past on a wait list for the psychiatric residential treatment facility, which by definition means that they have been medically found to not be safe in a community setting, which means it's very difficult for a foster provider to feel comfortable or safe bringing them into their home. Also might mean youth who has come to the attention of the child welfare system after Senate Bill 367, which was juvenile justice reform, when those behaviors that bring the youth to the attention of the child welfare system can seem dangerous or violent to potential care providers. We know that these behaviors are rooted in trauma, but nonetheless, they can be frightening for care providers. Since the question of youth having to rarely stay in an office or run away are the ones who do run away from placement, has been brought to the attention of the public by this committee. We have seen serious response by the state agencies. We have seen reduced wait lists for PRTF. We have DCF proposing crisis management for youth, which is another key result of ongoing focus on this population. And we have KDOC and DCF working together to improve our services for crossover youth. Nonetheless, there is more work to do, and we would like to just draw your attention to some possible activity that could be used, that could help us use the data that we're currently gathering and that we've been gathering for 2 years. We need I've listed some of those ideas in my testimony. I don't want to go through each one, but I do want to highlight some, especially the ones that have emerged over the last 2 years that are more current. One is that in most recent conversations I've had, whether it's with providers or partners or behavioral health experts, a common theme that we're seeing about youth with running behaviors is that youth are running at times because they have substance use addiction disorders and they're going through severe medical withdrawal, and we have no medical withdrawal management for youth in this state. So as they become physically sick and very uncomfortable, in addition to their addiction, they feel desperate to go back to use. Because social workers are not law enforcement officers, we can't restrain, we can't lock, and so often those youth are running back to use substance use. So we do need that view and that lens to be brought to this conversation. We also need to move forward from collaboration between the Department of Corrections and DCF on crossover youth and youth with juvenile justice issues, to really making sure that those evidence-based services contemplated by Senate Bill 367 are reaching this particular population. We can collaborate and talk about the cases for many hours. What we need is to be able to provide the interventions that those youth do need. Another issue you may not be aware of that I learned more as I have been getting more requests to look at this issue is the issue of the IDD waiver and how the lack of IDD services pushes youth with significant and very difficult to manage developmental disability needs into foster care merely because their families don't know how to manage their behaviors anymore and they are on a waiver and can't access services. So we know that this population of youth with chronic running behaviors has one or two or three or more of these complex multi-system challenges, and we would really want to look to your committee, since you're hearing this bill, to help us move from talking about this population to further action on this population. The last thing I'd like to mention is kind of summarizing that we were here 2 years ago and now we're here, and we're really grateful for your support in that. In Section 1B4, this bill contemplates that DCF would report on child welfare systems task force priorities every time they make a report. What I want to make sure, especially members who are new to the committee, that the task force was started in 2017, completed its reporting in 2018, made recommendations to this legislature at the beginning of 2019. And as I've mentioned, since then, in the last 2 years, significant steps have been made to implement the task force priority recommendations to this population, such as implementation of the Family First Prevention Services Act, improving youth access to PRTF, and collaborating across systems for crossover youth. We'd like to just ask this committee, if you're moving forward to pass Senate Bill 85, to make sure that the recommendation under section 1B4 is updated to reflect that we will have an emerging system, changing outcomes, changing data, changing federal opportunities. And we'd like to ask that you consider updating this section to be that DCF would make an annual report to the legislature addressing any legislative action needed to address the needs of youth with runaway behaviors or without access to stable placement, so that these recommendations can remain and relevant to the needs of the population. I appreciate your allowing me to speak to this committee on this issue. Again, we're very appreciative of your interest in this population, which is of the most concern to our members, and I am happy to stand for questions at the appropriate time.
Thank you, Rachel, for your testimony. And committee, Rachel is our only proponent today. Do we have any questions for Rachel? Senator Petty.
Thank you, Mr. Chairman. And Rachel, as always, it's good to see you. I am trying to clarify for myself. You're referring to 1B4. And
I'm trying to pull it up right now. It's line number 6 on page 2, if that's helpful.
right. So you're looking for, you're suggesting that DCF should be making an annual report that addresses whether what actions has been taken in this particular youth with runaway behaviors or without access to stable placement.
Yes, thank you for your question, Senator Petty. I'll try to clarify. What I did when I was reviewing the language of this bill is went back to the Child Welfare System Task Force priority recommendations. I realized that 3 of them have had major progress, 2 of them have not, but also 2 of them really aren't relevant to this population specifically. So what I thought was, if you're really focusing on number 4, what you're going to get is really the same kind of answers every time. And what we want is for DCF to be asking the legislature for help when they need it as systems change and emerge. So that was why I thought that perhaps an annual report about the needs of this population or the data related to this population would be more helpful for the legislature to really address the needs, rather than simply hear repeatedly about what we have or haven't done on the Child Welfare System Task Force from 2 years ago.
Thinking just as a follow-up, Mr. Chairman. So, I mean, I would agree, because I've sat on some of these task forces as well, we have had a lot of discussion about crossover youth. And so you're feeling that it would be helpful for DCF to pull out that specific information that deals with that population and focus on what's being done with this critical high-risk population of crossover youth and youth that without stable placement. Is this correct?
Yeah, thank you for the question and opportunity to clarify again. Yes, I would suggest, as someone who has been working with legislators and with DCF, KDADS, KDOC, and KDHE for, since around 2017, around this population, that we have different and changing systems every year, and that if this population is going to be an ongoing concern to this committee enough to request reporting on a daily basis, that we would want DCF to say, this is what we know about the population today. This is what we know about our needs for placement today. This is where our mental health system could help us support us today. And so that would be what I would anticipate in terms of an annual report or otherwise reporting that would bring up to date the Child Welfare System Task Force recommendations.
Thank you.
Senator Holscher.
Thank you very much. I also need a little clarification on that part. Is there already an annual report that is going to other branches, but just not to the legislature? Or am I just reading it maybe a little too much in depth?
I don't think there's an annual report on this other than that the DCF secretary would present to the Public Health and Welfare Committee and the Children and Seniors Committee and any other requested committee on a regular basis during the legislative session. So this could be something that she could present during those opportunities.
Great, thank you.
Senator Baumgartner.
Thank you, Mr. Chair, and thank you for the hearing on this bill. I actually introduced a version of it 2 years ago, so I appreciate that we're back on it. I'd like us to just circle back onto what would be on page 1, line 27. And Rachel, I'm in agreement with what you said, and I'm going to clarify what I heard you say. And that is a child spending an overnight period in a facility under the control of the contractor. So we know that children have spent the night in a facility, not so much a children's home, but in what would be the office of the contractor. But what I thought you said, but I know it to be true, is we need to expand that line to include those other places that we now know kids have spent the night that have gone into foster care. They've spent the night in cars and they've spent the night in hotel rooms. And so are you in agreement that those areas need to be included for that particular line?
Actually, Senator Baumgartner, that was not where my brain went to, but I would agree with you. I think that when we have children sleeping in any situation that isn't a licensed or approved placement intended for sleeping by foster youth, that would be included. Nobody wants children sleeping in cars or hotel rooms. So I would agree that if we could just clarify that it means that you report when they're in an unlicensed or not unapproved facility, but not report if they are in an approved facility. I think that's an important distinction.
Thank you very much. And Mr. Chair, I know that you were on the task force this summer, and one of the things I think it's important for this body, for this committee to know, is a part of the report was that settlement, that the class action settlement with the state, with DCF, and that's where we learned that DCF was feeling very positive that the average number of nights where children were staying someplace other than a foster home or a specific licensed facility was now the average of 16 per month. And that so significantly exceeded anything that we as a legislative body had ever been provided as far as information from DCF. So thank you, Mr. Chair.
Seeing no further questions for the proponent, we will now move our attention to the opponent. And with this, we have Greg Smith. He is the Special Deputy for Government, Veteran, and Crime Victim Affairs for Johnson County, I believe. Welcome, Greg.
Thank you, Mr. Chairman and committee. Good morning. For those of you that don't know me, background, I'm starting my 24th year in law enforcement. I did spend 6 years in the legislature, 2 years in the House of Representatives, and 4 years in the Senate. And I do represent the Johnson County Sheriff's Office on policy matters here at the State House. And our agency participated in Operation Hope a little over 2 years ago. I'm sure this committee is familiar with that. 18 Kansas DCF runaways were located in that operation, which was a federally led operation and investigation by the United States Department of Health and Human Services, Office of Inspector General, Office of Investigations, and I liaisoned with that Office of Investigations in our operations center in New Century, Kansas was actually one of the places where children that were recovered were brought to. And we're in opposition to the bill, not so much for what it does. This committee has oversight over DCF and all those policies, and we certainly respect that. But our concern is that there is a policy that was recently published by DCF in their Prevention and Protection Services Policy and Procedural Manual, Policy 5245. And this was published January 21st of this year. And it's the responsibilities when a child is missing from placement. The overriding feature of that policy is that it mandates reporting immediately and in no case later than 2 hours after receiving information on missing or abducted children or youth to law enforcement authorities. That's a policy. This is going to be a statute. And we're concerned that there's going to be a thought process that, well, statute supersedes policy, and we, law enforcement, may drop down lower on the list of who should be notified when a child is missing or abducted. We know that notification to law enforcement in a missing or abduction case is extremely important. We know in Johnson County, we're seeing an increase in runaways, whether they're DCF kids or whether not, that are runaways that are being at least subjected to or enticed by sex traffickers, labor traffickers. We're getting more and more reports of these all the time, and it's not just in Johnson County. This is not a local phenomenon. It's happening across the United States. We're always reticent to codify policy because once it's codified, it can't be changed as the situation changes. Some of these situations are fluid and dynamic. I mean, we have dozens, probably hundreds of policies with the sheriff's office, everything from how to wear your uniform to how to inspect your car before you take it out on shift. I mean, there's a policy for everything, but those policies, if something's wrong with them, can be addressed at that time by the agency. Whereas if all of that was in state law, we wouldn't be able to change it until the legislature came back in session. So that's our concern. This will go into law, and a contractor is going to be sitting there thinking, okay, I'm going to get fined $500 if I don't report this as quickly as possible to DCF. And the notification process to law enforcement gets superseded, for lack of a better term. So we're not telling you not to pass this bill. Our opposition is not on a reporting to the governor or to the legislature or even to county newspapers. But we just want to make sure that somewhere in there it's clear that law enforcement should be the first agency notified in these types of situations. Mr. Chairman, thank you very much for allowing us to testify today, and I'm happy to stand for questions at the appropriate time.
Thank you for your testimony. And just to clarify, if there is something in the underlying bill that states law enforcement has to be notified, your objection would be removed at that point?
As long as that's clear, Mr. Chairman, we would be perfectly happy with it.
Thank you. Do we have any further questions for the opponent testimony? Senator Baumgartner.
Thank you, Mr. Chair, and thank you so much, Senator Smith, for being with us. Just want to clarify, you want that to be included, but you do not want within the first 2 hours after a child's been missing. You don't want the 2-hour policy time frame to be codified into law.
Senator Baumgartner, Chairman Hildebrand, what we're looking at with the sheriff's office is just a concern that law enforcement has no mention of being reported to at all. That actually, the policy actually mirrors pretty much Kansas law on reporting someone that's missing, on how quickly we get information into the NCIC system and those types of things. So I don't have necessarily a problem with the language that's in the Protective Services policy. Our objection is more that there's no mention of law enforcement in this policy at all, and because this is statute, it'll be taken to supersede policy, not to mention the fact that there's a $500 fine if they don't report to DCF, and there's no fine if they don't report to law enforcement.
Mr. Chair, as a follow-up, Senator Smith, could you share with us, do you feel that law enforcement is informed almost immediately? We know that certainly didn't happen with regard to the 3 kids that went missing for months in Tonganoxie a couple years ago. So do you think that there has been a change that has occurred with regard to notifying missing children, runaway children, within the foster care system within the last 2 years?
Senator Baumgardner and Chairman Hildebrand, I can only speak from what is available in our records, and I did do a short research through those. I will say this, that since Operation Hope, there has been a marked change in reporting, and I can't say it's 100%, but I would say that there's definitely been an improvement.
Thank you very much, Mr. Chair. Thank you.
Seeing no further questions for the opponent, we will now move our attention to neutral testimony. And the only neutral testimony we have is from Tanya Keys. She's the Deputy Secretary for the Kansas Department for Children and Families. Welcome, Tanya.
Good morning, Chair Hildebrand and committee. Is my sound okay?
Yes.
Thank you. Thank you for the opportunity to present information on the important issue, Senate Bill 85. And as you're aware, this bill really relates to the responsibilities of notification on two pieces: when a child is missing from their placement, or when a child has had an experience of an overnight office stay, and then thinks about the notification to the governor, the legislature, and local newspapers. DCF is neutral on this matter. As you've heard today, many of these attributes are already in federal law and state law and DCF policy. Wanted to spend a couple of minutes on the matter of children who are missing from their placement or on run. Federal law and state law requires that DCF report a missing youth to law enforcement and register on the Center for Missing and Exploited Children's site within 24 hours. Our policy is more narrow than that. Our policy requires that would be reported to law enforcement within 2 hours. That's a little bit of background on our policy. Our policy also requires that we contact caregivers, the parents, and we're also really pleased, and some of you are aware of a special response team that's been developed about 1.5 years ago or 2 years ago. We have 10 positions across the state with our contracted providers for foster care, as well as 2 DCF employees who are non-case carrying. They are dedicated towards supporting prevention, recovery, and development of youth who are on run. Those special positions help with some of these reporting pieces. They help with surveillance and tracing to help locate these youth who might be on run using social media and other tools. They work closely with law enforcement as well as KBI in their work in special response for these youth. And they also do a lot of our documentation and follow-up for those youth. Secretary Hauer receives a daily report regarding youth who are on run. And as it was mentioned, that information is posted daily on our public website. Yesterday, there were 69 youth who were reported on run from placement. And from that information, we're able to get a bit of trend in terms of gender, their ages, and how long they have been in that missing or on run status. We want to provide a little bit of information. There is information in statute under conditions under which we can provide case-specific information to different legislative committees. There are 6 committees: House and Senate Judiciary Committee, House Corrections and Juvenile Justice, House Appropriations, Senate Ways and Means, Legislative Post-Audit, and then any other joint committee with authority to consider children and families issues. So a little bit of background on who within legislative structure can already receive that. The other piece we wanted to briefly talk about was children who are in foster care spending the night in an office. DCF is committed to eliminating children being overnight in an office by October 31st of this year. As been mentioned, there was a settlement agreement approved earlier this month in a federal court by Judge Crabtree, and one of those conditions was to eliminate the use of offices. So we've been working very hard on this and reducing it. What we know in terms of the frequency is that the first 6 months of last year, fiscal year 20, there were 98 instances across those 6 months of youth staying in an office overnight. And we know this year, this fiscal year, the first 6 months, there have been 43. So we are making progress. We know there's more work to do, and we're committed. We've talked a little bit about the effect of this legislation, and specifically wanted to bring up again the technical piece on line 27, page 1, and line 3 on page 2, where it describes facility under the control of the contractor. And just maybe an unintended consequence that's been mentioned is that our contractors do operate facilities that are licensed for the placement of a child. For example, a psychiatric residential treatment facility or a qualified residential treatment program. Those are two facilities that are licensed and that children would be residing there receiving treatment. One option of, to sort of remedy that unintended consequence of the word facility might be to exchange it with the word office. Office is used in the settlement agreement, and also it's been suggested to use the term a facility that is not licensed as a placement. Those might be some technical options.
Yeah, I apologize. I'm going to interrupt you because we are almost out of time, and there's another committee that is going to, waiting for this. If we have a brief question or two, we'll take one or two brief questions, and then we'll adjourn. Senator O'Shea.
Mine isn't, thank you, mine is in general. One of my concerns is on this, it says that we need to they need to contact legislatures, and so what will count as being notified? An email, a text, a phone call? Any legislature could say, well, I haven't been notified. So that lack of clarity is what I am confused about. Thank you.
Maybe we can get some clarification at a later time from Revisor on that issue. Okay, no further.